You
There you
cannot
go.
hear me.
Yes,
Okay,
I can
well,
hear you
could people know? Okay, did I do a whole monologue with people not hearing me?
now. I couldn't hear you the whole way through, so
Okay.
yeah.
Well, you know what? That is just the joy of doing shows.
Yeah, you roll with the punches.
I will roll with the punches, and thankfully, everybody could see what I was talking about, so it just is kind of like, okay, whatever. All right. Well, thank you, Kyle, for being with us. Kyle is a named partner at Hickman, Robinson, and Yaege. And Kyle, well, I'll just repeat what I said when nobody could hear me, which is that Kyle will be helping us avoid buyer regret. Because a lot of times when buy and it's not even just like, okay, there's buyer regret. You also have to make sure as a seller that you do what you need to do to make sure that the buyers are happy so that they don't regret things. Because guess what happens when buyers regret things? They come after you as the seller because you're the easiest target. The people, their real estate broker is usually somebody that they know and like. So they're not going to sue their real estate broker unless what they did was really bad. And who else are they going to look for? They're going to look at the selling agent, the listing agent for not disclosing something, and then they're also going to sue the seller because, hey, why not sue everybody I can sue?
Mm-hmm.
Right, Kyle?
That's exactly right. Yeah.
um,
But
yes,
you're the easiest target because you've got the attorney's fees clause in the purchase agreement.
exactly. That is also true. Because the attorney fees clause means, okay, I can sue you with very little risk. Um, and then we're going to just, somebody else will pay all of my attorney's fees.
If you win.
If you win. And how easy is it to win in San Diego or in California?
Well, so California, you in a lot of states, real estate transactions are truly a buyer beware. There's, you get your inspections period. If you don't find it, it's on you. California is the exact opposite. You have an affirmative obligation in California to disclose any material fact. And the way that material fact is defined is it would cause a reasonable person to change their opinion about the desirability or value of the property. And so I have seen non-disclosure cases over some of the most interesting things. Like, you didn't disclose to me that there was a noisy road outside when I bought this. Well, the road was there when you came and looked at it, but it didn't stop them from filing a lawsuit. People really try to stretch the definition of what material is in California because it's up to what this fictitious reasonable person would be.
And we both went to law school, but for the viewers who did not go to law school, I am curious, how reasonable is the reasonable person?
I think that each jury gets to basically make up that reasonable person in their mind, and I think it differs with each panel. So be careful who you pick for your jury, I guess.
Okay, and then that's I guess your job, or
that's part of my job. That's part of my job.
Cool. Yeah. So what exactly does it mean when you say a reasonable person would want to or not want to buy the property or change the valuation of the property? You said the noisy road, but could it be like, oh, this floorboard creaks, or
the question
this
is,
bathroom isn't permitted?
Yeah, I've had a number of those cases. Like, I had one that we handled a while back that was, are you familiar with Waterhammer?
I'm not familiar with Waterhammer.
Waterhammer is it's the result of plumbing installed too tightly in the walls, and basically, if it's not installed correctly, as pressure changes in the pipes bounce. So when valve opens or closes, or the pipes expand and contract when they get cold and hot, it'll bang. And we had one property that there was no disclosure of a water hammer problem at all, and it sounded like the flippin' poltergeist. Like my client had videotapes of like these 10-minute long bang, 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 bang. It was like you did not know. Yeah, like you knew that this was here and you chose not to tell us about it. There's no way that you owned this house for 10 years and had no clue that this like ghost in the closet every night water hammer thing was going on. It can be, squeaky floorboard might be an overstatement, but if a person living in that property knowing that fact would go, I don't think this is what I want, or this is materially affects the value of the property. I would want it for less money. Then it's going to be up to that reasonable person, that whoever that person is in the mind of your jury, and you don't want to be in that chair. Unnecessarily. I generally give people the advice, over disclose, because I've seen very few real estate transactions. I'm a broker too, just like you.
Right.
And I've seen very few transactions blow up where on that other line you wrote, there's, this valve squeaks at night, or those little minor annoyances. Nobody's going to kill the deal over that. You can put it in there and say, take it or leave it. They may send you a request for repair and ask you to spend a bunch of money to do it, but you're free to say no.
Exactly.
And it's better to have it in there and know that when they come around, they have regrets later on and they want to find somebody to go after, you can point to that piece of paper and say, here it is.
Yeah, absolutely. I often think about it as kind of like dating and then marriage. It's like if you're dating somebody, you're kind of in love, you really like each other, you're like, oh, the fact that you kick me in the middle of the night is kind of adorable.
Yeah, for now.
And then afterwards, 10 years in, you're like, why did I marry this person who kicks me in the middle of the night? This is terrible.
Yep.
And so it's very similar.
Yeah. No, people do fall in love with homes when they decide to buy them.
Yeah.
And nothing, those small little trivances that you put them on that other line in the SPQ and TDS disclosure documents in California, nobody's going to kill the deal over that. Very rarely. But if you don't put it in there and then they have regrets later on, depending on how angry they are, and whether they can convince an attorney it's worth taking on some sort of contingency. They do have to. Most real estate attorneys, at least here in San Diego, aren't taking a bunch of cases on contingency. They're hourly, so you don't have folks that are shopping those deals. They show up occasionally, but so if they want to really press a hard claim, they're probably paying out of pocket for it. If they're angry enough and they want to pay to go to the distance, you're likely to have a dispute that's probably going to see a jury if there's a way to argue that reasonable person, you got to get through the judge on summary judgment, but that reasonable person's a dangerous person to deal with.
Yes, the reasonable person is not reasonable most of the time, I think. And out of curiosity, do you typically represent? Do you do like half and half? Do you typically represent buyers? Do you typically represent sellers?
I've represented all the players in the game. I've represented the brokers. I've represented the buyers. I've represented the sellers. Depends on the transaction. I don't exclusively represent anyone. I don't do a whole ton of broker defense. I typically am dealing with one of the principals most of the time.
Mm-hmm.
But occasionally we have brokers, and for one reason or another, they aren't using the standard panel counsel for their, insurer, and come to us.
Yeah. And I'm kind of curious, do you find that it's easier to represent one side versus the other?
No, I mean, it really depends on the facts. I think that, like most kinds of litigation, neither party's 100% comfortable and neither party's 100% happy.
Right.
But it really, nobody wants to be on the bad side of the facts. And most of the cases are, there's a bad side of the facts. There's a clear, you should have either disclosed something or it was disclosed and you're just making a big deal out of a small thing.
Right.
Occasionally you get one that's a true jump ball, but for the most part, it's clear from the initial set of facts, okay, this is the side I'd prefer to be on.
Right. Yeah. And do you do you sometimes turn away clients because you're like,
oh, I feel like the most valuable service I provide to people is the service that I don't really get paid for, which is the consults on bad cases where I explain to people why their cases are bad and they probably shouldn't chase them down.
right, that is absolutely.
Yeah, I mean, they call me thinking sometimes that they've got a slam dunk case, and I walk them through the facts, and I ask the questions, and I look at the documents, and we sit down and go, okay, this is what the other side's arguments are going to be. This is what your arguments are going to be. Here's what this sounds like, and do you really want to have this amount of money on the line to get to that jury to know that these are the kind of the arguments that are going to be made by the two sides? Knowing that whoever wins is going to get their attorney's fees in addition to whatever damages, and whoever loses gets to pay the other side's attorney's fees in addition to what they've already paid their attorney.
Right.
And
you get to pay for two attorneys.
You get to pay for two attorneys, and so that's part of the benefit actually of the pre-filing mediation that's written into the car contract.
Mm-hmm.
Mediations in a lot of circumstances are not worth anything until you're right on the doorstep of trial. I will say I have had fantastic luck with the pre-litigation mediation on non-disclosure cases. So it's I always approach those expecting to have a serious conversation about settlement because most of the time people appreciate the risks of not resolving that kind of case.
Right, exactly. And generally, as you kind of said, it depends on who, you can be on the good side of the facts, you might be on the bad side of facts. And it really depends.
Yeah. I don't like representing one side over the other. I don't think there's an inherent edge that one side has over the other. It's pretty well balanced, and I wouldn't be able to tell you which side I'd like to be on until I know the facts. That is definitely what dictates most of the case.
Yeah, definitely. I think that, the facts kind of dictate it. And I mean, I guess one of the questions, and this will probably be like a nerdy lawyer question, but I'm a nerdy lawyer, so I get to ask that, is, at what point do you really have the facts that you need? Do you get it kind of at the beginning, or does discovery disclose or help you find facts that you really needed to know? Or
the answer is I do my best to have as many of the facts as I can before I've even contacted the other side. I try to do my research there because oftentimes in discovery, I as much fun as discovery is, which is, I'm saying that sarcastically, it's apart from depositions, the odds of getting a whole lot that's beneficial through discovery apart from documents is pretty low. You can spend a lot of time on paper and not get a whole lot that's beneficial. Depositions and request for production are different because email is for evidence. I've had more cases turn on the contents of email correspondence between parties and their agents, and between the agents and that kind of thing, than anything else. Like, emails are amazing. It used to be that you had to really need to document something before you'd write a letter. Now you can blast off a 2-sentence email saying, I'll deal with X tomorrow. And then when you don't do it tomorrow, there's your document showing that you knew it was there and that you intended to deal with it and you didn't.
Right.
The document side has value in discovery, and I regularly learn new things there. But that and depositions are really the place where I learn new information. You learn new information through the entire case, but I try to learn as little new information. Plan on learning as little new information through discovery as possible, and instead have everything in the file beforehand that I can, so that I know what direction it's likely to go.
So essentially what you really are trying to do is, okay, here are the facts. I need documents to support these facts, but you don't actually want to be learning anything through discovery.
I don't want to be learning new things. I very often do learn new things. I don't want to be learning new things in discovery. I want the case to look exactly the way that it did when it walked into my office as the day that I'm going into trial. Rarely is that the case, but that's my goal.
Right. And I'm curious, sort of from the discovery process, which I think when you're thinking about trial, I really think that discovery is probably one of the longer portions of the trial process. Getting
Definitely
documents.
One of the most expensive.
Yeah, well, definitely one of the more expensive. I mean, it's what, an hour, not an hour. It's like a couple hours to, draft a letter, draft a complaint or whatever. And then, just imagine going through 500 emails.
Yes. No, it's people wonder when you go to trial and they see the exhibit binders that the attorneys bring in, and it's 4 3-inch binders or 6 3-inch binders of documents, and they're like, how can this little bitty case involve that many documents? And it's like emails. Yeah, no, people don't realize how much paper they generate. It's just not on real paper anymore. It's all digital.
Yeah. So I guess if you had advice for a home seller, like in terms of emails, because you've been talking about it, what would you advise them with respect to emails?
Well, I mean, most of the time the home seller is only corresponding with their agent. I would say if there's something that they have questions about how to disclose on the SPT and TDS, that they need to try to get advice from their agent, and more likely than not, when they do, their agent's going to refer them to somebody like me. Because there's just understanding how to phrase it so that it's clear, that you've disclosed it, and that the other party has an obligation to inspect it further if they want to. It's as much an art as it is a science. That's one of the more frequent calls that I get. Like when a dispute hasn't existed, there's no issue. It's just the middle of the transaction and somebody's calling me out of the blue. That's the question I get. This thing happened. This condition exists. What do I say? What don't I say? And it's important to get that piece right. And I think that if they've got doubts, it's better to go spend a couple of bucks on a consult to figure out exactly how to phrase it and make sure that it's in there correctly than it is to just kind of wing it. Yeah.
Yeah. I mean, I think the one example that I really like is the golf course example, which is, if you say, we're next to a golf course and, periodically golf balls fly through the window, then, the 5 a.m. lawn mowing, which might upset the neighbor, then is not disclosed. But if you say something like, I don't know, property is...
You're still muted.
Now you can hear me.
Yes.
Sorry.
No problem.
Need to move my hands less when I'm talking. No, but like if you're next to the golf course and you just say, property is next to a golf course with, whatever risks associated with that, then you have encompassed all of the things. You've encompassed the golf balls, and you've encompassed the lawn, and you've encompassed the, crazy drunk people that wander into the backyard. If that's an issue, you've really sort of encompassed everything.
Yeah, when I have people come to me,
and now I can't hear you.
Really? Well, that is interesting. Can you hear me now? Can you hear me now, Frantz? No.
But these are the joys of doing things live.
I didn't touch anything. Let me see if I got something on microphone. All right. You still can't hear me, right?
Well, while we are trying to fix Kyle's microphone, I will do my introduction of Kyle, which I actually did not do before he started talking. So, Kyle Yaege is a named partner at Hickman, Robinson, and Yaege. He has been a real estate attorney for the past 15 years and primarily focuses on anything real estate related, including landlord tenant law, real estate failure to disclose transactions, as well as providing advice and consultation to clients before they litigate. He also does things like draft leases, review leases, and provide representation to landlords as well as tenants. And fun fact, he was, well, I won't disclose how old he is, but he was named one of the 40 under 40 notable people when he was under 40 years old. And I'm going to have to figure out what to do. I'm going to have to figure out what to do temporarily. Hi, are you
All
back?
right. Can you hear me now?
Yes, I can. Hello.
All right.
Hold on just a second. Okay, cool.
All right.
All right. Well, thank you for viewers. Thank you for bearing with me and figuring out bearing with us. This is what happens on live TV. This is the fun of doing stuff live. But regardless, I don't remember what we were talking about. We were talking about disclosures.
Yeah, we were talking about disclosures. I'd like to talk for a minute about things that buyers can do to avoid having that problem. You know, the disappointment and temptation to go after people, because I think a lot of people are. I don't want to pass judgment and say lazy, but a lot of people they're like, oh, I'll order a home inspection and that'll be it. And
I like to use the word energy. I like to use the phrase that people like to conserve energy.
Mm-hmm.
Their energy. They try to be as energy conservationist as possible.
Yeah. No, there's a number of people that, because they're not familiar with real estate transactions, they see this. Oh, well, we'll get all this paper and we'll look at this paper and we'll have this inspection and that'll be it. And the things that people get disappointed about with a house are things that you can generally spot if you spend some time in the property and you talk to the right people. So I encourage people when they're when they're in escrow, they're doing their inspections, make a point to go to the property at different times of the day. Go there in the morning, go there in the middle of the day, go there in the evening, stop by a couple of hours after dark, like as if it's not occupied. If it's occupied, you got challenges. But if it's a vacant property, you can generally get in there with not a whole lot of issue from the seller. And just seeing what the neighborhood's like, walking around and using all the lights and kind of using the property the way that you would, will teach you a lot about a property and whether it's going to be what you expect it to be. The other thing is knock on some doors. Knock on some doors. The neighbor often is happy to talk to the person who might be their neighbor tomorrow. They might be nutty. They might be completely crazy, and you want to know that. But it doesn't take a lot to go next door, across the street, and talk to them and say, hey, I'm in escrow to buy the house next door. So long as there's not some special confidentiality issue where they don't want to know that it's being marketed for sale or something that's different. But if on a normal market sale where the sign's already out in the front yard and everybody knows that it's on the market, go knock on the neighbors' doors, see what they know about the history of the property, see what they know about the neighborhood. They're generally more than happy to talk to you.
That is absolutely true. And also they will sometimes tell you what they do. So
Yeah.
I remember I had a friend who sold their house, and these were people who were known as the people who threw dance parties every few months on their roof. They had like
Mhm,
a balcony on the roof, and they were known throughout the neighborhood as the people who did that.
mhm.
So I mean, they sold their house, so it doesn't really matter. But if you were buying the house next door to them,
Mhm.
you probably could know, hey, these are the people who throw the dance parties every couple of months on their roof, and you now know that there's going to be a bunch of noise
Well, I mean,
coming from their house.
I have a case, or not have had a case where my client bought a home. The home inspector looked at it and signed off on everything, probably because he was completely asleep at the wheel. But the
That aside.
they bought the house. The next week there was a torrential downpour, and it wasn't just a leak in the roof; it was a deluge. Like it came through. It destroyed their TV. It destroyed pieces of their furniture. It was not like, oh, there's this little leak over here that we need to patch. It was a flat out deluge. And they go across the street the next day and knock on the neighbor's door, and he's like, oh yeah, the owner over there. Every time it was going to rain, they pulled out this great big tarp and they wiped it out on top of the roof. And they were like, you're kidding me. And sure enough, like they had taken photos. They had taken photos of the neighbor putting the freaking tarp out on top of their house. And you want to know what was missing from the SPQ and TDS? Any reference to leaks in the roof. Just
Right.
not there. Not there. So yeah, talk to the neighbors. If they had talked to that neighbor while they were in their inspection contingency, they may have said, hey, we need to have a roofer come out and look specifically at the roof, and made it a condition, requested repairs and required that it be fixed before they closed.
Yeah, which I think is really helpful. I think I mean, in some circles, people refer to lawyers as deal killers, but I think that neighbors kill more deals than lawyers do.
Neighbors cause a lot of drama. Yeah, I can agree with that. There's both neighbors that kill deals because they walk in and they go, hey, did you know that this happened on the property? And when they come and say that after you've closed, it results in a non-disclosure lawsuit. If they say it beforehand, it kills the deal. Either way, it's not good for you as the seller.
That is actually true. And, since I also teach property law, I think I want to kind of bring in everybody's favorite. I mean, if you did this in law school, the favorite disclosure case of the haunted house, right? I don't know if you read that, where not like, if you ever find it, I will maybe put this up next week. But if you ever read the case, it's very funny. It's like very punny. There's a lot of puns in it or whatever, because the judge was absolutely not taking this seriously.
Yeah.
But I mean, at the end of the day,
you're required to disclose if somebody died in the property recently.
That is true. And in this like poltergeist haunted house situation, the seller or the buyer actually did prevail. This was in New York, but the seller prevailed, or the buyer prevailed, because the seller did not disclose that this house was haunted. So I'm curious, what, like, okay, I suppose if you believe in ghosts, then obviously you can say this house is haunted. But if you don't believe in ghosts, if you fundamentally just don't think that ghosts exist, then what can you do as a seller to say this house is haunted while still maintaining your own personal integrity that I don't think.
Well, I mean, I think you can say, prior owner disclosed that this was haunted when I purchased it, or I was told by my great aunt Sue that she saw something in the attic. But truth of the matter is, I don't think that the odds of actually having that be a material misrepresentation at the end of the day are not great, unless they've got you on tape or something saying, oh, I can't live here anymore, the ghost showed up for the 15th time. I mean, like, if there's a record where you've been talking to the world about how you've got a problem with the poltergeist in your closet, and you didn't put that on your SPQ and TDS, then you got a problem. But if you didn't see it, you don't believe it, there's no record of you having seen or said anything, and nobody disclosed it to you, how are you to conclude that it's haunted?
I think that's fair. And I think, this is actually probably something that could be true in certain neighborhoods in San Diego. It's definitely true in like Louisiana, where there are houses that are just like known throughout the neighborhood as being haunted. I think that's like true in Mission Hills. There are certain houses in Mission Hills that kind of just have this reputation for being haunted. So if you buy it, you will know that it's haunted. And not only is that, do you know that it's haunted, like people like visit it on ghost tours, or like they, walk by it around Halloween. And so, in that case, I think you probably, maybe you don't disclose this house is haunted, but you can say, we've got a bunch of people who walk by the house.
I think if the ghost tour comes around to your house, you need to disclose that the ghost tour comes around to your house. There's no two ways about that. Whether you believe in the haunting or not, like the San Diego ghost tour trolley stops by on Wednesdays at 4. You probably need to put that in the paperwork.
Absolutely. And then the other thing that you mentioned was, deaths on the property. Actually, there's actually an interesting, I don't know how much you can talk about a specific fact, but like, certain deaths, I think it's like 3 years. You have to disclose death on property for 3 years. But then I'm thinking of like the Rancho Santa Fe sort of like Heaven's Gate situation. That's not 3 years. I think that's just something that you have to disclose forever.
This is the place where a mass suicide occurred, is probably something that's required for that property.
But then the question that I have is, apparently they like renumbered the property and destroyed it, and it's not that property anymore. So in that case, is it still a required disclosure, or is it a new property? Like, has it been reborn?
If I was selling it, I would absolutely put it in the disclosure. I don't care if you change the house number or not. Like you can change the house number for luck, whatever. But if your disclosure doesn't say this is where the Heaven's Gate closed the door, then I think you've got a problem.
So that is something that probably needs to continue to be disclosed.
Yeah, I mean, can you imagine selling it to somebody and then that person 6 months later sees a documentary on Heaven's Gate and goes, "Wait, that's my bedroom." Yeah, like I would not want to be on the wrong side of that lawsuit, because I can imagine a jury thinking that might not be an okay outcome.
Right, exactly. Of you buying the Heaven's Gate mansion and
there are a number of those kinds of, just the property has a reputation outside of a particular category, where it happens to be, famous for something or another. If your property is drawing unique attention, where people are stopping by to take pictures outside of it, or like, if that's a risk, you need to put it in your disclosures. It's cheap insurance. If they're in love with the house, they're going to think, great, it's another unique thing about the property.
Right.
It's so much better to just put it in the disclosure than to not and risk having somebody come back around.
Yeah. Or also the other thought that I have is like, there's the mushroom house in La Jolla Farms, and people like stop by and take photos of like mushroom thing on the beach. And so that's also something that hypothetically, if these people ever decide to sell, probably should be disclosed.
Yeah. I think that if you've got a notoriety, I'm sure that it's the same if you have a home designed by a famous architect. This was designed by this famous person, and occasionally we get inquiries, or we get visitors who want to see it from the outside or photograph it or whatever. And for most people, that's not going to be a deal breaker. But if you don't disclose it, it may, for the famous architect side, if you don't disclose it, that's on you, because you should have been advertising it, because it probably increases the value.
That is true.
But for some of the other things that you can have a reputation for a property, it's not great for the value, but it's better to disclose it than to not.
Yeah. I mean, as you said, very few deals die because of over disclosure.
Yeah. If you've got something that you're intentionally trying to hide because it's going to depress the value, you've already answered your question about whether you have an obligation date.
Exactly. Yeah, that's absolutely true. So, I mean, the other sort of thing that, and I guess there's like no real smooth way of moving into the questions about sort of landlord tenant and all of that. But like, I think one of the questions that I have is, with respect to disclosure, right? Let's say you have a house and it has some sort of issue, and it really would be very hard to sell if you sold it. So you say, I'm not going to sell this. I'm going to instead give it to a renter, right? I'm going to rent it out so that I don't have to disclose these things. Like, are there disclosure requirements for renters in the state of California?
So the answer is yes.
I mean, it's California, of course.
Yeah. But believe it or not, the same standards apply. The only difference is that in executing a lease, you don't have a statutory form that you're obligated to give the other side that affirmatively represents here are the defects.
So basically, if you decide instead of selling the Heaven's Gate house, you're going to rent out the Heaven's Gate house, you would need to disclose that to a potential renter that this is what it is.
The answer is yes, but the scope of the damages of that tenant who chose to lease from you because they didn't know that fact and otherwise wouldn't have are minuscule compared to the buyer who just paid whatever our new median is, $1.4 million, or
well, in Retro Santa Fe is probably worth like $5.
Oh yeah. Well, depending on where you're at, it's it's more than that.
Yeah.
But yeah, your scope of damages for that tenant's going to be smaller, so the risk that they're going to actually turn around and sue you is smaller, and your contract is not the standard car form contract in purchase and sale for the most part. Most of the landlord-tenant, residential leases, if they have an attorney's fees clause at all, have an attorney's fees clause that's capped at like $1,000. So the consequences of that non-disclosure in a landlord-tenant scenario are itty-bitty compared to what they are in the purchase and sale transaction.
And also, when you have a lease, then you take the house back at the end of the lease.
Well, and if they discover something that causes them not to want to lease it because they don't think that the rent's right, you can say, fine, why don't we just agree to terminate the lease and you can go somewhere else?
Exactly. Which much harder to do that when you buy a house.
Yeah. And I'll give you a segue for the landlord tenant issues from purchase and sale. I don't know if you had any of these when the COVID epidemic was kind of at its apex, the late spring through late summer of 2020. But as all of the moratoria and stuff were getting passed, I was actually trying to 1031 one income property into another income property at that time. And on the buy side, I had so many income properties where the broker was actively concealing the fact that there was a tenant that was behind on rent and hiding behind the COVID moratoria to prevent eviction. Like they'd post rent rolls that made it look like the property was cash flowing. And they wanted you to get committed and into escrow, and then they wanted to spring it on you at the last minute. And it was like, no. So I actually, before I started submitting offers anymore, I after the fourth or fifth one where it was, I called the broker up and I'm like, are the tenants current? Are they all current? If they're not current, I'm not giving you an offer. Because it got so frustrating, and it's like that's a material misrepresentation if you don't disclose that sometime in that paperwork, they were just trying to get you hooked, get you into contract, and then they'd give you the disclosure 5 days in or 6 days in after you've invested in the property, and they're like, oh, we'll help pay to evict the tenant. Well, I'll tell you how good that was.
Well, yeah.
So here's the transition into landlord tenant. Now that we're in the how good that was.
Yes.
I had a number of residential evictions in that era where the process that before COVID, I'll say before COVID and before the Protecting Tenants Act, because both of those had an impact on this, would have taken me 2 months, 2.5 months to get soup to nuts, file all the way to writ of possession with delivery by the sheriff and a lockout date.
Which basically means they want to evict you until you're actually not able to go back inside.
Until the sheriff shows up, lights and sirens, and says, get out, they're changing the locks.
Right.
So that process was, before all of those things, 2 months, 2.5 months. I had a number of cases during that era where the process beginning to end was more than 11 months.
Yeah. And that's 11 months of no rent.
Yeah. And we're still dealing with that. I have a number of cases, I have one in particular that we're now at 5 months since filing, and there's the tenant actually showed up and tried to fight it, and they couldn't assert a single dollar defense. There was no reason for them to not be paying rent. They just didn't, couldn't, wouldn't, shouldn't. And there was it wasn't like they were entitled to the rent relief programs. We've got a million of them in California now. And by the way, those take forever. I don't know if you've got any experience with that.
Yeah, I do. It was, yeah.
Yeah.
They're painful.
They're not well managed. And I got a call on one of my properties that I manage last week, saying that the program in San Diego has run out of funds again. So I don't know if there are other programs that are still funded or not, but I think that money may have finally dried up.
Yeah, I think it actually has.
Yeah,
which is not good for people like you, but
well, the problem was that the current state of affairs up through March, if you had an application pending, that barred you from pursuing the unlawful detainer.
right.
And because it was taking the county their sweet time, 3 months or more, to tell you whether you even qualified for it,
Right.
you as the landlord were stuck. You were just sitting there twiddling your thumbs, waiting for the county to get around to looking at the file. So it's not great. We're finally getting to a place where the system is getting back on its feet. But I will tell you, I don't know what year you started practicing, but there was once upon a time in a land far, far away, before the Great Recession, when we had four unlawful detainer departments in San Diego. 4 of them. There is one. And that one is having to deal with the 1.5 to 2 years worth of eviction backlog created by COVID. It is taking forever right now to push paper through the unlawful detainer court. It's really tough. Yeah,
that is true. Also, just out of it's out of curiosity, and this kind of goes to people who might want to rent their houses instead of sell them. Which, frankly, I have clients who come to me and they're like, I'm thinking of buying a property and doing an investment, or I want to become a landlord. And my general response is don't. Right now, the answer is don't. If you haven't done it before, don't do it now. Wait.
Yeah. I as a residential landlord myself, I can say that without me being in the business, I would have given up a long time ago. Without me kind of knowing the ins and outs of how to manage the property, what kinds of things I want to install in real, you don't install the nicest countertop in your rental property. You don't pretty it up the way you do your house, because tenants will destroy that. You need something that's going to be durable, and that you're not going to cry about if they break it.
Exactly.
And it's a fine line. It's got to look nice enough that they want to pay to rent it, but you don't want it to be so nice that it's going to really hurt if they break it. And it's most homes, when you're, going out and buying a home that's not currently being used as an income property and turning it into an income property is a recipe for some really tough news if you're not aware of what you're looking at.
Right. Yeah, that's absolutely true. And I do think, when I talk to people, they think, oh, I'm going to be a landlord. And that means that I get to buy a property and then I keep collecting checks every month. And it's like, no, that's not it. You're writing checks every month.
Mm-hmm. Well, and I prior to the last 12 months, I had served all of one statutory notice on a tenant on a property that I managed. Like, I had done a really good job of screening tenants and choosing ones that were going to pay on time, not going to cause a lot of drama, just be good tenants. And I currently have one group that I've experienced. I've served 5 notices in the last 12 months. And they're not rent notices. They're not always rent notices. They're other things. When you run into trouble as a landlord, you run into a lot of trouble.
Yeah, that's really true. And also, if you just think about it, like, if the person isn't paying their rent on time, then there's going to be other problems. Mm-hmm. Just like as a practical matter, it is very rare that somebody who cannot afford to pay rent just cannot afford to pay rent. Like,
yes. Yeah, no, and people should be aware that this is something that is news for those folks that are considering being a landlord. The credit agencies don't go vacuum up unlawful detainer judgment data. They stopped doing that in 2017. So your credit check company, if you pay your credit check company for an unlawful detainer search, odds are that data is incomplete and it's out of date. You should absolutely go to your local Superior Court index and run the name of your potential tenant through the index, because they are not vacuuming that stuff up, and they're not publishing it in the credit reports anymore. They stopped doing that a while ago.
Does that include for a judge if you have a judgment for non-payment, or
so civil judgments as well? They stopped vacuuming up unless you've got a reporting agency who's actively trying to collect the civil judgment.
Okay.
So if you have a reporting like a bank, right, or a credit card, they're a reporting party, and that's absolutely going to be on their credit report, whether it's a judgment or it's just a delinquent account.
Right.
But if it's their prior landlord who's not a reporting agency, then that prior landlord's judgment isn't going to show up. It's not going to show up whether it was an unlawful detainer or it was something else, unless they've sold that judgment onto a collections agency that is contracted to be a reporter to TransUnion and Equifax and those guys.
Right, and they might not want to do that because those companies do not pay you the judgment. Yeah. They pay you.
Well, they don't pay you full price. Yeah.
No, they will pay you less.
Yes, they
often a lot less, which is why you can easily negotiate with them to accept less than the judgment amount.
Yeah, but it used to be that Equifax and TransUnion would actually go down to the courthouse. They'd have an agency go down to the courthouse and pull the names off the judgment roll and try to match them up to the credit reports. And they stopped doing that in 2017.
That sounds like a lot more work than they're willing to do.
Well, they got dinged for misidentifying some judgments, and California passed a few statutes, and they just decided it wasn't worth continuing to have that be part of their report and leave folks to fend on their own to look for civil judgments.
Yeah, well, that definitely sounds great. Well, we didn't actually have any viewer questions today, which is interesting. Last week we did, but I asked you plenty of questions. Hopefully everybody felt like this was useful. I definitely really appreciate your taking the time to chat with us, Kyle. And do you have any last words before we end for today?
No, it's just been great being here. Happy to talk to you. I'm sorry I didn't generate questions, but if anybody runs into something further on, I'm happy to try to help.
Yeah, well, I think the technical issues mostly on my side did not help. The also the not hearing was apparently also on my side,
Yeah.
not on your side. So yeah, it's fine. You know what? Episode 3, we're kind of trying to find our groove, and I appreciate your working with us. It's always a pleasure to chat with you. And if people want to get a hold of you, how can they do that?
They can call me at the Hickman Robinson Yaege office. We're on the internet, Hickman Robinson Law. The main telephone number there, 619-819-8383.
That sounds awesome. And you said that was 619
819
819
8383.
8383. I will put that up so that we can see that, maybe. Yes, here we go.
Hey!
619 819 8383. Yay! Okay, I have succeeded doing one thing today, and I think that is good. Well, thank you so much, Kyle, for being with us. And next week we'll be here with another guest, another real estate pro who will help you find the pros and avoid the cons. I wish all of you a really great weekend, and thank you for joining us.
Have a good night.
Have a good night.